Let's see. All right, the chair lacking a gavel will hit his pen on the table. It's time to call the meeting to order. Good morning, everyone. This is the Board of Appeals September 11th, 2020 meeting, and we're holding this virtually using the WebEx platform. We just inserted that little advertising. To start, let's review the online protocols. So one person will speak at a time with no side conversations. Please mute your device to improve the audio quality for all of us. Raise your hand and wait for recognition by the chair before speaking. Prior to speaking, please state your name. Speak slowly and clearly and as close to your microphone as you can. Please limit distractions by turning off your mobile phones and any other devices. Make sure children don't interrupt. And we'll take a break each hour. So I'd like to begin by introducing the members of the Board of Appeals. So when I introduce you, if you could check your audio and give us a good morning. We'll begin with Stacy Aguiar. Stacy, are we good?
I'm good, present.
Thank you. For Steve Hirakami.
Good morning, present.
Hi, thank you, Steve. Springer K. Do we have Springer? Did we hear anything from Springer? Okay, perhaps she'll be joining us soon. Heather Kimball.
Hey, good morning, everyone. I will.
Hi, good morning.
I'll text Springer real quick and see what the story is.
Thanks. Justin Lee. Got your audio, Justin?
How about now?
That's good. Thanks.
Okay.
Neil Thomas. We'll just go with Neil.
Yes, Neil is fine. Good morning, everybody.
Good morning. With the chair here in the conference room, counsel to the board is the Deputy Corporation Counsel, Diana Mellon Lacey, to my right.
Good morning.
To my left is the staff to the board, and that's Bethany Morrison to my left.
Good morning.
Keiko Mercado is our staff, our WebEx host in Hilo. Rob Leisure is staff to the board. He's our WebEx co-host in Kona. And then with us is Melissa Dakayanan Salvador. She's secretary to the board. Okay. So for our agenda items, Kuhonua Bioenergy, LLC, the Board of Appeals 19-00227 has been continued until December 11th of this year. Greta Spear, Board of Appeals 19-00238 has withdrawn as of 8/28/20. A new business matter that we will hear today is James Sturz, Board of Appeals 20-000256. To be heard, it's an appeal of decision by the Planning Director dated December 20th, 2019 regarding denial issued for short-term vacation rental registration. The STVR was 19-361627 and non-conforming use certificate, NUC-19-1462. The location is 53-3947 Pratt Road, Kapa'au, Hawaii, 96755. The TMK is 353006030. Timothy and Rhonda Robertson, Board of Appeals 20-000258 has been continued until January 8th, 2021. I'm sorry. Are we good? Okay. Yeah.
2100.
21 something. Timothy and, Andrew Odell, Mary Elizabeth Lachek, and Richard B. Rocker. BOA 2000269 is continued until November 13th of this year. And the AOPOO KOVP Incorporated, BOA 2000270, will be heard today, September 11th, 2020. It's an appeal of the decision by the Planning Director dated March 23rd, 2020, regarding the approval of a variance application, VAR 2000571. There's no physical address assigned. The TMKs are 372-006-004. Subdivision is 17-001699. There'll be a board determination regarding whether to accept the July 2nd, 2020 petition for untimeliness. The relevant ordinance in the board rules, Hawaii County Code 25-2-58B and Board Rule 8.3. If the board accepts the petition, there'll be a contested case hearing. There has been a request for a continuance in that matter. The next item is of similar AOPOO-KOVP Incorporated, BOA 20-000271, to be heard today, Friday, September 11th. It's an appeal of the decision by the Planning Director dated May 23rd, 2020, regarding amended tentative approval of subdivision application SUB 17-001699. There's no physical address assigned. The TMK is 372-006-004. The subdivision is 17-001699. It's a board determination regarding whether to accept the July 2nd, 2020 petition for untimeliness. Again, relevant ordinance and board rules, Hawaii County Code 25-2-58B and Board Rule 8-3. The next matter would be a contested case hearing if the board accepts this petition. So, prior to beginning the agenda, are there any statements from the public on items on the agenda? Seeing none, does the staff have any of the testimony that's been received on these matters? Bethany, have we received anything?
No, we have not.
Okay, thank you.
There was one that came from Mr. Ivanovic.
There was just that one.
Yeah, there was one from Mr. Ivanovic.
Yes, I seem to remember that. That was for STRS.
Yeah, that was for sure.
It came in very late, did it not?
Yeah.
Yeah.
Okay, has that been?
I think it had previously been submitted, and it was a resubmission of a letter that he had previously submitted.
Okay. Have the board members received copies of that testimony?
Yes.
Okay. So now I'll read into the agenda. James STRS, Board of Appeals 20-000256. This is an appeal of a decision by the Planning Director dated December 20th, 2019, regarding the denial issued for short-term vacation rental registration, STVR 19-361627. And the non-conforming use certificate, NUC 19-1562, the location is 533947 Pratt Road, Kapa'au, Hawaii, TMK 353006030. Mr. STRS, are you here?
I am here.
Okay. Please state your name for the record.
James STRS.
And for the Planning Director? Hello?
Are you asking me to respond or for the planning director to?
No, I'm asking for the Planning Director to read into the record their presence. Do we have contact with the Planning Director?
Yes, it seems like they might be muted.
Yeah, I see John. Is that John?
There's a hand.
Okay, he's acknowledged his presence.
Oh, only to state his name for the record, so.
Okay. I'll begin, are we going to get them?
Yeah, we should be able, Michael, are you able to connect to audio?
I don't know how we can do this. Yeah.
We're going to use the old-fashioned walk to the next room.
Yeah, they have to put their name.
Yes. Good time for a sip of coffee. How are we doing?
Yeah, I can do that.
His microphone is not working.
Okay, I'm gonna move them and you can come here.
Okay.
The county seems to be experiencing some trouble with bandwidth.
So here's an extra chair, if you want to pull it over.
I'll just stand.
Okay. Okay, so we have Mr. Sturz read into the record. We'll read the Planning Director and Council, John Mukai, into the record.
Hi, good morning, Chair and members of the board. John Mukai, Deputy Corporation Counsel on behalf of the County of Hawaii Planning Department. Also present is Michael Yee, Planning Director. And at this point, Chair and board members, I would like to move to continue this matter in order that the Planning Department be allowed to file a motion to dismiss in its entirety, because on August 13 of this year, the Land Use Commission for the state of Hawaii ruled that short-term vacation rentals cannot be used in agriculturally zoned properties. Now, I don't have a copy of the physical decision yet, and I would need to attach that. I understand Mr. Sturz will argue that there may be an automatic approval, so it should be granted. It's the Planning Department's position that even assuming, but we're not admitting an automatic approval, the Board of Appeals simply cannot apply something that is contrary to state law, and we will be filing a motion and request a continuance so that we may file it.
Thank you, Mr. Mukai. But prior to that, Mr. Sturz, do you have your audio on?
I do. Can you hear me?
Yes, I can. I'm going to ask you, based on the nature of this year, I need to determine prior to hearing any other matter whether you have properly provided notice to the surrounding property owners in accordance with BOA Rule 811D, which would be 20 days prior to this hearing. And have you filed proof of service or made good faith efforts to serve notice on all property owners within 300 feet?
Yes, I have, and I have submitted to your office that proof.
Bethany, do we have that? We will check that prior, because if that has not been accomplished, then we will have to continue this hearing prior to even.
Sharon said it has.
I'm sorry?
On August 28th. We received this copy.
And so it was sent on August 15th, which is more than 20 days prior to this hearing. So the board finds that the matter has been served properly. So at this point, we have a request for a continuance from Mr. Mukai, representing the Planning Director. I'll hear arguments regarding this from Mr. Sturz at this time, if he has any.
I do. May I speak?
Please.
So I am aware of the LUC declaratory ruling. I was not a part of that suit that was brought before the LUC. I think that it was only a declaratory ruling. There is no doubt, I suspect, among any of us that it will be appealed, and that the larger issue of short-term vacation rentals and NUC will not be resolved until it reaches federal court. Because I was not a party to that declaratory ruling, to that case, I do not believe, furthermore, that it even applies to me. As Mr. Mukai has said, there were significant procedural defects and violations of the law that the planning director, either wittingly or unwittingly, committed in denying our registration and application, and we would like to have that righted, and that's what we're here to do today, I hope. So we strongly disagree with having a continuance and having this case dismissed.
All right, thank you. Mr. Mukai?
Well, whether Mr. Sturz was a party or not, the Land Use Commission's decision, which has yet to be issued in writing, is the law for the entire state of Hawaii. That decision has statewide implications, and of course it does affect Mr. Sturz. As we sit here today, that's the state of the law, and even assuming Mr. Sturz is right, that somehow there were some errors in processing, and an automatic approval cannot apply, because if it applies, it would be contrary to the State Land Use Commission law as it stands today.
Mr. Sturz, any further comment?
I do not agree with Mr. Mukai. I think the very nature of the land use hearing, the Land Use Commission hearings, were that no facts were considered. It was just a ruling. I think that it is important in individual cases to consider the facts, and I think when the facts are considered, I hope that the Board of Appeals and that even the Planning Department itself will understand that an error has been made and there's an opportunity to right it.
Mr. Mukai?
We agree that there were no factual determinations, but the Land Use Commission was asked to interpret the state law regarding the agricultural use, and it determined that the short-term vacation rentals are not a proper use in agriculturally zoned lands as a matter of law.
Mr. Sturz?
The Land Use Commission was asked by the County of Hawaii and by Rosehill et al. Again, I was not a part of that. And I believe that the Land Use Hearing Commission declaratory ruling affects those who were part of that action. I was not part of that action. And I believe that I still have the right to have my individual case heard.
Again, we would disagree because the Land Use Commission specifically interpreted that portion of the Hawaii Revised Statute, Section 4.5, which related to proper use on agriculturally zoned properties as a matter of law with statewide implications.
Nevertheless, may I speak?
Yes, please.
Nevertheless, the Land Use Commission, which was not provided any facts, made assumptions of fact that while probably true for most cases, are not true in our case. And it would be a miscarriage of justice, if that's the appropriate term to use here, to assume that because most agricultural lots are one thing and ours is entirely a different thing, that it would apply to us. And I can give specific examples.
Yes.
I think we're not here to argue the merits.
Yes.
This is a matter of the interpretation of state law by the State Land Use Commission, which ultimately has the authority to make that decision. And as we sit here today, the Land Use Commission has in fact made their determination.
Thank you. At this time, I'm going to ask if any of the board members have questions for either of the parties. I'll begin with something akin to a roll call. Stacy Aguiar, Stacy, do you have any questions for the parties on this matter?
Not at this time. Thank you.
Yes, and before I make a ruling, you'll have a chance. Just raise your hand in the future, and we'll try to recognize that. Steve Hirakami, do you have any questions?
Yes, I do. I want to know if, am I unmuted? Okay.
Yes, you are. We can hear you fine.
Okay. I want to know, prior to the Land Use Commission here ruling, were STVRs approved? And if so, would this ruling reverse that approval? Because I'm sure there might have been some vacation rentals that were approved prior to the hearing, and if so, I want to know if the law, because I think in Mr. Sturt's case, what he's arguing is the timing of the ruling. So I just wanted to know that if anybody can answer that question.
Mr. Mackay,
I think on any agriculturally zoned properties, you have to fill out what's called a farm dwelling agreement. And so basically it provides parameters that you would be doing agriculture or agriculturally related activities prior to the ruling.
Yeah, I know, but did the County of Hawaii issue any non-conforming use permits for any STVRs prior on agricultural land prior to the hearing? Prior to the ruling by the Land Use Commission? That was my specific question. And if so,
clear to you?
I think I understand the question.
Steve, yeah, I think Mr. Yee will respond.
Michael Yee, Planning Director. So if I understand the question is if we approved vacation rental applications on agricultural land, per the ordinance, certain agricultural land prior to this 1976 date, they were not farm dwelling units. They were considered single family units. They were allowed to get a non-conforming use certificate. So you had to be on a pre-76 lot. If you were a post-76 lot, you received a denial from the department.
Is that your question, Steve?
Yeah, that's perfect. And then another question, could you identify who's on that phone, the 8083, and there's a couple of there. Could you identify who's on that phone call? Thanks.
Steve, you were breaking up a bit. Could you repeat the question?
Yeah, I noticed there's two
Excuse me, at this time, could you, everybody put their speaker on mute if they're not Steve Hirakami?
Thank you. No, I just wanted to see if we could identify, I know there's two people calling in, 8083 something something ends with 70 and 8089 something something ending with 35. Can we identify who's on? I can't tell what the person or who that is. Thanks.
Okay, I'll ask our staff to determine if, to see if they can determine that. At this time, we're going to move, Heather, did you get hold of Springer?
Yeah, Springer is on. Yeah, she joined us.
Hi.
Yeah.
Hi,
and I have a question, just a question. So I believe the motion on the floor is to allow for a continuance of this matter so that the planning department can file a further request for dismissal. Mr. Strutz, do you have any objection to continuing this matter at this time, since that's the motion on the floor?
I do, yes. The Planning Commission has been continuing this motion month after month after month. The first time, because of the LUC hearings, which I continue to say do not apply to me. I also would like to ask, if I may right now, that Mr. Hirakami's question was a very good one, and he did not receive an answer. The specific answer was, have any STVR denials been subsequently approved, and will those now be negated by the LUC hearing across the board without exception?
Okay. Just to clarify, Steve, was that the intent of your question?
Yeah, that was my intent. I think that, you know, if the state law is going to prevail over our county planning director's decision, then will it hold true for any STVR that were previously approved that now do not meet the qualification as per the Land Use Commission? That was my specific question.
Thank you. But again, I think we're getting to the underlying matter, and that's not what we're here to discuss at this moment for this motion to continue. But I understand why you're concerned with this, Steve and others. Heather, do you have any further questions? I'm sorry, Springer.
No, thank you. I had the same question, so that's fine.
Okay. All right. Heather, do you have any questions?
No, I'm good. Thank you.
Heather, say again.
I have no further questions. Thank you.
All right. Thank you. Justin? Justin, are you on mute?
Hi, no questions. Thank you.
Thanks. Neil?
I do. Thank you, Mr. Chairman. I understand this motion is because the Land Use Commission hasn't actually put out a ruling in writing. I know I've only seen newspaper accounts myself. Do we know that they actually plan to come out with something and on any particular schedule?
Thank you. Mr. Mukai?
Yes, my understanding is there will be a written decision. I have no idea when it will be forthcoming. Also, it still hasn't been posted on YouTube yet, so I don't know how far back they are or even when this decision will be available.
A further question, if I might, then, a follow-on. What's the downside of our hearing this matter on the merits now, aside from having to guess what the Land Use Commission might actually come out with later?
Well, we know what the ruling is. They made the ruling, they interpreted state law. And so, assuming you go forward and you rule in favor of Mr. Sturz, it would be an illegal application of state law. We know what the decision is. I just don't have the physical decision with me now.
Well, they haven't come out with a decision, and if we were to rule in Mr. Sturz's favor and something then comes from the state that invalidates it, I suppose you'd have no choice but to circle back and deny it, wouldn't you?
Again, we know what the decision is. It was a unanimous decision. So moving forward, and it would be a nullity. There's no use in proceeding.
Neil, are you getting an answer that you want?
Well, I'm trying not to get into the merits of this, but there is a factual consideration of this being a ag land subdivision prior to 1976, but it was subsequently subdivided. So there's another question about whether it's a newer subdivision and falls within the ambit of the ordinance as opposed to something that kind of has grandfather rights. I don't know if we want to go there yet, but
Yes, it's
There
too
is.
premature to go there. We're going to just deal with the motion in front of the chair at this time.
I'm fine with that. Thank you, Mr. Chairman.
Okay. Let's see, are there any further questions from any of the board members that have gone through the roster? Yes, Steve.
Yeah, I want to know if rather continuing and filing a motion to dismiss, if they couldn't discuss a motion to dismiss right now at this hearing and we could decide on the merits or whether we should dismiss it or not. Why do we have to continue it to dismiss when we have attorneys here that can make a motion before the planning board to dismiss this this claim, and we can argue the merits of that. And if we don't dismiss it, then we can argue the merits of Mr. Sturtz's appeal.
Chair,
Thank
this
you,
is
Steve.
Springer. This is
Yes.
Springer. I'm not sure if it's appropriate to discuss, but I don't think I'd feel comfortable arguing or considering the motion to dismiss without the written decision by the Land Use Commission. Although we understand the gist of what they have decided, I think it makes more sense to have that in hand before we decide on the dismissal.
Thank you, Springer. Steve, just to advise on the motion to continue, that's a decision made solely by the chair as a matter of our rules, and so I'm going to consider that prior to anything else. So your suggestion or your observation is fairly noted, but let's finish any arguments regarding this motion to continue. And does anybody else have any question or comment at this time from the board?
Yeah, this is Heather Kimbrough. I share Springer's concern about having the ruling in hand in writing prior to making a decision. I think it would be premature to go into the factual arguments of this case when we could not solidly make a ruling if we ultimately made the determination that the LUC's decision applied, since it doesn't exist in writing yet at this time.
Thank you, Heather. Any other comment or question? If not, the chair is going to rule on this matter. The chair is going to grant the request, the motion to continue on the part of the planning director. I consider it necessary to do that, to have an orderly and just hearing on this matter. We need to have that in hand. So at this time, we will continue until, we're not sure of the date, but I'm going to assign a date. And I'm going to say, I think sooner is better. So let's go till the 13th of November, which would allow time for the decision to be published and disseminated, and for arguments to be made on the matter. Are you in agreement?
That's fine, Chair.
And Mr. Sturz, are you in agreement to continue to 11/13, or do you have another date you'd like to propose?
11/13 is fine if I must ask for another date. I would prefer an earlier one in October.
Mr. Mukai, do you think that's realistic?
I don't know. I know that there are still planned LUC decisions that are in the hopper before ours, so I just cannot make any, I don't know when they will come out with their decision.
Yeah, so Mr. Sturz, part of my motivation for pushing it back an extra month was to make sure that you're not unfairly having to notice your surrounding property owners to be back on our agenda come October, what is our October date? October 9th. Because if we get that hearing out or that decision out and it's towards the end of this month, while, you know, it's fair to say you might be able to assimilate that and make arguments in October, I'm not sure we'd meet our 20-day notice requirement. So I'm going to make it November as our scheduled date, November 13th.
May I say something? And I appreciate your logic with that, and I think it's absolutely correct. There is obviously an element of harassment that I am being forced to participate in of my neighbors by sending them these repeated notices. I've now sent 3. I will have to send a 4th. And if this goes on and on, the very process of sending these letters is going to have an effect on them that can only be deleterious to me. So the very process is working against me when it should be objective. And in my particular case, it has been anything but objective because the planning director has allowed himself all sorts of irregularities that he would never have allowed from an applicant.
I would object to that last comment on behalf of the planning director. Move that it be stricken from the record.
Objection sustained. Thank you, Mr. Sturz. I do, though, appreciate your predicament. You have to understand that there are forces much greater than any one citizen of the county. There's a number of people that are in the similar position and predicament as you. You, however, do have an appeal in front of us. You are required under our rules to notice your surrounding property owners, and I can understand how that could end up having a, as you say, a deleterious effect on your relationships with them. Unfortunately, those are our rules, and when we have rules in front of us, we're going to follow them. So at this time, regrettably, on your behalf, we are continuing until November 13th. Thank you.
Thank you.
Everybody, why don't we take a break? 5 minutes, 10 minutes, something. Give yourself a short pause and we'll talk to you in 5 minutes.
I think we've lost video with the host.
And am I entirely finished at this point for today?
Oh, I'm sorry, Mr. Yes, with granting the motion to continue, that is your curtain call. That's the end of the matter.
Thank you. And will I receive, I guess, written notice about this and about the November 13th date if it is going to occur and not be continued again?
You will be given notice. I'm sorry?
We'll hold the hearing.
Yeah, we're going to hold that hearing, and you will be called in for a pre-hearing conference again.
I know there was supposed to have been a pre-hearing conference between this one, before this meeting, which never occurred, which is I guess my concern. You'll recall that when we spoke on the phone prior to the last continuance being granted, we agreed that there would be another pre-hearing conference, and that never happened.
If that is correct, it was an oversight, and we as the board apologize for that, Mr. Sturz. But we will have a pre-hearing conference with you prior to November 13th.
Okay. Well, thank you very much. I wish you all a good day, a good weekend. We'll meet again.
Thank you.
All right. Have a good day. Bye-bye. Aloha.
Aloha.
It's not working though. Unmuting. What's on? Can you hear me? Okay, but I want to mute it. Yeah, still okay. Oh, can you hear me? Can you still hear me? That's not good. Can still hear me. Can you hear me? Shauna, can you hear me? Okay, good. What? You can? Can you hear me? Can you hear me?
I can hear you. I can hear you, and your mute button was on.
Christy, talk now while your button is still on mute. Just talk right now without touching anything. I think you may have fixed it because we don't hear you.
Good morning, Mr. Matsukawa. Could you please speak to test your sound?
So a board member, April Supernant is the Deputy Planning Director.
Good morning, Mr. Matsukawa. Can you hear us?
Let me unmute. Hi.
I think you are on mute, if that's you speaking.
Okay.
Yep, great, thank you. All right. Aloha, Kathleen. Could you please speak to test your sound? Do you see the unmute button, Kathleen?
Okay.
They're just checking.
Okay, I'm unmuted at the time.
Terrific, thank you. You may go back on mute. Christy
Where
Logan,
can we
could you
hear
please
that?
unmute and test your sound?
So Mike, you're still muted.
Yes.
Yes, good morning. I finally figured it out.
You're a little soft, Christy. I don't know if you can speak closer to your microphone.
Sure, how about that? Is that better?
That's a little bit better, thank you.
Okay.
And Paula Alu, good morning. Would you please unmute yourself and test your sound?
Good morning, this is Paula Alu. How's my sound?
Thank you very much. Perfect, thank you.
Okay.
So, Chair, I believe we have all the expected participants for this next case.
No.
Introduce yourself.
Kayam Pamafuga.
Hi, I'm Shauna Fuga.
Hello? Hello? Can we get a sound check from the chair? That's not good. You talking? I think you're gonna have to go next door. Hello, chat. Sound check.
Michael, we can hear you.
Was that an affirmative that you can hear us?
Yes, affirmative.
Thank you.
It looks like the chair is still muted.
Hello, can you hear me?
Okay.
All right, if you can hear me, please raise your hand.
Okay.
All right, we're back in action.
I think you have to start again.
Okay, forgive me, I've already done this twice. This will be the third time. This is the agenda item AOPOOKOVP Incorporated, the Board of Appeals number 2000270. This is an appeal of the decision by the Planning Director dated March 23rd, 2020, regarding approval of variance application 20-000571. The location has no physical address assigned. The TMK is 372006004. Subdivision number is 17001699. This matter is the board's determination regarding whether to accept the July 2nd, 2020 petition for untimeliness. The relevant ordinance and rules, the Hawaii County Code 25258B, and the board rule is 8.3. To advise the Board of Appeals, at a pre-hearing conference, the parties agreed that this initial hearing would be limited only to the issue of untimeliness. Mr. Matsukawa has requested an in-person hearing for the underlying matter. Okay? So both the Planning Department and the landowners have filed a motion to dismiss. These motions will be heard. Mr. Matsukawa, who filed a response to these motions, will then be able to respond. Because they're very similar, I'm going to request that the Planning Department present their argument first, and then the landowners' motions will follow, then followed by Mr. Matsukawa. If any of the parties plan on calling witnesses, I'm not aware of that. Do any of the parties intend to call witnesses? Mr. Matsukawa, you do? For this motion to dismiss? Unmute Mr. Matsukawa.
I had a proposed direct testimony, a portion of which has facts relevant to the motion.
Okay, so do you have a witness for today on that matter, on that fact?
Yeah, Kathleen can verify that these statements are the statements that she wishes to make in support of the motion. I mean, against the motion. This is in regards to, yeah.
Yes, the motion to dismiss. Okay, all right. I just wanted to know what's in front of us. Okay, so at this time, I'd like to call the Planning Director or Council forward to make their motion to dismiss.
Thank you. John Mukai, Deputy Corporation Counsel on behalf of the County of Hawaii Department of Land.
Excuse me, John, you'll either need to get closer to the mic or you'll need to project your voice a bit better. I do the bellows breathing technique.
Okay.
And I drop my mask.
Okay, this is John Mukai, Deputy Corporation Counsel on behalf of the County of Hawaii Planning Department. Also present is Michael Yee, Planning Director, and in this case, Chair and board members, we filed a motion to dismiss or in the alternative for summary judgment. We would urge the board just simply look at two things. First of all, the Planning Director issued his variance decision on March 23, 2020. And the appellants for the Association of Property Owners of Kona Ocean View Properties filed their appeal on July 2nd, 2020. Now, when the Planning Director issued his variance decision, he properly notified the property owners, the Paula L. Alu Trust. The appellants, the association, has failed to timely file within 30 days on or before April 22, 2020, as provided in Board Rule 8.8-3, the Hawaii County Code Section 23-5, Hawaii County Code Section 25-2-20, and even assuming arguendo, but not admitting that somehow the COVID stay of 60 days applied, the appeal should still have been filed no later than June 22, 2020. Now, the association, the appellants are arguing that the moment they found out about the director's decision, they filed their appeal. Now, if you use this logic, then why even have jurisdictional time limits? Because anyone would just say, well, I just found out about it, so guess what? This rule doesn't apply to me. The appellants also argue that they never found out because the director never informed them. Again, the director notified the property owners as required, or any interested party who may request such information. Now, the surrounding property owners were notified, and that can be found in page 2 of Exhibit B, paragraph 9 to our submission. Now, if the appellants wanted to, they have a mechanism to be informed of any of the director's decision arising out of the property in issue. Rule 1-8 of the County of Hawaii Planning Department provides that all public records shall be available for inspection by any person, and that copies of records printed or reproduced for persons other than governmental agencies shall be given to any person. Rule 92F also provides the appellants a mechanism to request such records from the planning department. Under Rule 2-71-11, an informal request could have been made by the appellants to the director to provide any and all decisions arising out of TMK 37-2-006-004 subdivision 17-001699 at any time, but they never did. Under Rule 2-71-12, under the rules of the UIPA, a formal request could have been made by the appellants to the director to provide any and all decisions arising out of the same property referenced earlier, but they didn't. Under the circumstances, County of Hawaii Planning Department would urge that the July 2nd, 2020 petition for appeal in response to the planning director's decision of March 23, 2020 be dismissed.
Thank you, Mr. Mukai. At this time, we'd like to hear from Ms. Logan. You're representing the appellee. Ms. Logan?
Yes, I'm sorry. I was struggling to get the mute to unmute. Thank you. Good morning.
Good morning. Please present your motion to dismiss. Yeah, this is for the variance now. The single case in front of us is 270 for your reference.
Correct. I actually have a question. I'd like to move to amend my motion to dismiss for untimeliness, to substitute untimeliness for the fact that this variance is not a decision that's appealable. And I want to put that forward instead of the untimeliness.
So you're not
sure. I can tell you that I support Mr. Mukai's motion for untimeliness, but if you're asking me right now about my motion, then I'd like to move to amend it and do a substitution.
Have you submitted this motion to the board?
Substitution? No, I want to make that motion here in the hearing, as I'm supposed to be allowed, and I submitted Exhibit 2.1 a couple of days ago, which I've been told the board's received.
Yes, we have that exhibit.
So I would like to move to amend my motion to dismiss for untimeliness by substitution, but I'm not sure how, if we're dealing with just Mr. Mukai's motion to dismiss for untimeliness, if you want me to respond to that, or you want me to deal with my motion at the same time. So I'm a little confused there.
I would
Yes.
go back and let people, take any questions on Mr. McCall.
Yes.
The letters presented separately because we're not joined.
Sure. Thank you, Ms. Logan. At this time, we're going to move to Mr. Matsukala's response to the motion to dismiss made by the planning director. And after we go through that process, if we're still in hearing, we will hear your motion as well.
Okay. Thank you. I'll
on this matter.
mute myself now.
All right. Yes, thank you. So, Mr. Matsukawa, can you unmute at this time?
Yes, I have.
Okay. Your response to Mr. Mukai's motion.
Well, first of all, I don't want to repeat what I filed in opposition to the motion. What I do want to highlight, however, are some critical facts that are not disputed. First of all, under the subdivision code 23-17, a person who applies for variance is required to notify in writing property owners having property within 300 feet of the subject area. The planning director so informed the applicant in this case. The record on appeal would be page 23. On the application itself, at record on appeal page 20, there is no listing of the appellant, the association, as the owner of property within 300 feet. And anyone can scale off the distance from the affected land in question and would conclude that the association's road, the private road in question, lies within 300 feet. They were not given notice. More importantly, the applicant's affidavit of service, record on appeal 47, only refers to the sign, which, by the way, is not posted on a public highway. It's posted on a private roadway. But the affidavit of service does not contain any statement that copies of the variance application was served on any of the named adjoining property owners, and obviously not the association. The planning director had informed the applicant that this was the applicant's responsibility to do under the code. Now, what happens here is apparently because no notice was given and the association's identity as an adjoining owner is not listed in the file, it seems that the planning director, when he issued his decision, never realized that the association was or should have been treated as an interested party. This is especially relevant because the association had been objecting to the underlying subdivision application, and so the planning director, of his own knowledge, should have known of the association's interest in the variance as well. But besides the point, the association did not receive notice from the applicant per the code and per the planning director's letter. So when the planning director submits his notice, his decision on the variance, nothing is sent to the association. Curiously, on the same day of the decision on the variance, the planning director had sent a copy of the subdivision, tentative subdivision, amended subdivision approval to the association. So he sent a copy of the underlying decision to amend the subdivision approval to the association, but did not send a copy of his decision of the variance, which is related to the amended action at all. So what the county is arguing in essence is if the applicant does not conform with the code, and if the planning director is misled into thinking that the association in this case had been notified and had expressed no comment, that the failure of the system should work against the property owners, the association in this case, which is kind of turning the law upside down. Most importantly, the county in its motion does not refer to several Hawaii Supreme Court decisions, which are very much on point on what happens in this kind of situation. And per our opposition memorandum, we argue that if there is no notice given in violation of the underlying code, then there is no time limit until a reasonable time when the association discovered the information. I think it's an improper argument to say someone who is entitled to notice under the code of a variance application has a duty to apply under the general planning department rules to be informed of information affecting the property. That's, I think, a red herring because they were entitled to notice in the first place. Why did they have to submit a request to be informed when the planning director had informed the applicant to inform the association? That's it.
Okay, thank you. At this time, I have a question.
Chair, we lost your audio.
Excuse me, sorry for that. I had to confer with council. So at this time, Mr. McKay, do you have a response, rebuttal? Mr. McKay?
I have nothing, no further argument at this time, Chair.
I have
Okay.
a question.
So, yes, please. Yes, Ms. Logan?
I believe the case that Mr. Matsukawa is referring to regarding notice, in that particular case, the person that was appealing, the code did not require notice at the time that case happened, and so that's why they actually didn't get notice. And so the facts of that case are far different from the facts in this particular case. And the county did notify per their requirements. And like Mr. McKay said, the record can be reviewed at any time. Thank you.
Thank you. Okay, so for board members, questions? Yes. Neil?
Yes, the drift of the opposition to this motion is that notice wasn't given and that they should be allowed to start the clock when they found out about it. Can we please pin that down? I think there's something in the record to the effect that they were at the county office in a meeting and that's when they sort of found out about this variance request, and it'd be good to have that date in the record, please.
Are you, is that part of the record you're familiar with, Planning Department? We'd have to check that, Neil. It's volumes of information.
I think Mr. Matsukawa would know, because he
Can you provide that
in his memo.
I think
it would have to be.
I think Kathleen can answer that. She was the person
Well, if you're going to call her as a witness, then we have to swear Kathy.
Okay, so,
She would have to
yeah, Mr.
testify.
Matsukawa, is that your witness eventually?
Yes.
All right, we'll wait until we swear her in.
Okay.
Okay. So,
Thanks, Judge.
Any other questions from the board regarding this motion?
This is Springer case. So it seems the question is just whether the association was noticed or not. And forgive me, there's a lot of paperwork here. I'm trying to find. Do we have that list of who was notified? Can someone identify that exhibit?
Yes, it would be the record on appeal on page 20. The record on appeal was delivered on July 15th. It'll have Michael Yee on the top left, and it'll say index to record on appeal at the center. It'll be a document of about 75 pages. And on page 20, see a list of the properties within 300 feet of the TMK.
Thank you. And I guess can you confirm whether they are on that list?
Are you referring to can we confirm whether the Association of Property Owners of Kona Ocean View Property Incorporated is on the list?
Correct.
Is that your question?
Yes.
Yeah,
Who to address it to, Chair, I apologize.
No, they're not on that list on page 20.
Yeah, they are not listed.
Thank you.
When did they?
Are there any other questions?
Hi, Chair. Justin Lee, I have a question.
Yes.
So I guess this goes to both parties, or all three parties. What's the criteria for an interested party?
I'm sorry, are you referring to our actual board rules?
No. In a situation such as this, the issue is interested parties have to be notified. So I'm wondering what the criteria, the threshold is to determine who is an interested party.
So as a surrounding property owner, you're curious whether, for instance, a corporation versus a person might be a distinction made?
Yeah, because I recall in Mr. Matsukawa's filings, there was some issue about an interested party being, maybe I misread it, but more of a fluid definition. I was wondering if we could have more clarification, and it might be a disputed point between the county and the association, but who would qualify as an interested party that's required to be notified in an action such as this?
So our board rules are 8-11. D, notice to surrounding property owners. The applicant shall mail a notice of the hearing to all property owners within 300 feet of the affected property. Said notice shall be given to persons required to be notified under section 25-2-4 of the code. So we will find our answer in the code. Yes.
Pardon me.
Yeah.
Do you have a code now?
You need the zoning code?
2524.
Yeah, I thought I had it too, but, no, here we go, I do have it, yeah. I can't see with my glasses on.
We're having technical issues here based on the barometric pressure and the humidity in the microenvironment on Diana's eyeglasses.
Here we go, 2524, sorry.
So 2524 states that notice shall be served to the owners and lessees of record of all lots of which any portion is within 300 feet of any point along the perimeter boundary. Such notice shall be served on the owners and lessees of record So we don't have any further definition beyond the owners and lessees of record. So the property in question that Mr. Matsukawa is arguing has not been noticed is the road lot. Is that correct, Mr. Matsukawa?
Yes, that's correct. It's the road lot.
So who is the owner of the road lot? Is it the Association of Property Owners?
That's correct, the appellant.
And they hold it in common?
No, the association holds it under a deed from Mr. Dang, which is one of the exhibits that we have. No, it's in a record and appeal.
Okay.
Mr. Dang deeded the roadway to the association. And so in response to board member Lee's question, I think he was really asking for the purpose of the variance application, what's the criteria? And 2317 of the code says that the application shall be given to owners of property within 300 feet. And it's the same criteria that the board uses for notice of its hearing. And if you look at record on appeal page 20, which is the list in the application, it does not include the association. And if you look at record on appeal 47, which is the affidavit of mailing or proof of service, there is no reference to notice being given by the applicant to the association.
Yes, under procedures for variances, section 2317A, within 3 working days after receiving notice of such date, the applicant shall serve notice on owners of interests in properties within 300 feet of the perimeter boundary of the applicant's property, and the owners of interest in other property which the director may find to be directly affected by the variance sought. I don't know that the director specified any, but that would be the general requirement.
Stacy has a question on Justin.
Yes, Stacy, please. Stacy?
Just so I can, for clarification, the motion on the table that we're assessing is whether or not the appellant's application was filed within the 30-day or within the timeline for the board to even hear their objection. Is that correct?
That's correct. The question of timeliness.
So the Mr. Matsukawa's position for the association is that, just so I'm clear, is that they were not notified on the date that the director approved the variance, thus their time clock didn't start ticking from the date of approval?
And the date that all the other property owners were noticed. All the others were. Everybody on page 20 was noticed except the lot. That's what Mr. Matsukawa has brought before the board.
I see. And is the is the association on record listed as a separate TMK where the appellant or appellee would have known that they should have been on this list?
Yes. In the record on appeal for the subdivision, I believe, there is a copy of Mr. Dang's deed to the association, which was the deed of record back in 2002.
And so for clarification, the list of individuals on page 20 are not the same individuals who have a shared interest or hold the deed for that shared roadway.
That's
They
correct.
are not the same individuals.
That's correct.
Okay, thank you. I have no other questions.
Justin and Steve.
Okay, Justin?
Just have to unmute myself. I have two questions. The first is, I see the list on page 20 that everyone's referencing. I just don't see any proof in the record of appeal that even these individuals on page 20 were noticed. Is it there?
If I might answer,
yeah.
If you look at page 47 of the record, there is no reference to the other owners, Member Lee. There's only references to the sign.
Correct. Okay, so I guess my follow-up question is to the county or to the property owners. Is there any other notice other than the sign on page 47? Whether it be to the association or the surrounding property owners?
No, this is John Muka on behalf of the county. My understanding is nothing else.
Okay. All right, Ms. Logan, I think.
Ms. Logan?
Yes. Yeah, I believe that the county published in the newspaper variance. I'm not sure how that would look in the record that the county has, but I believe that was the posting of the sign and the notice in the newspaper.
So is there a copy of the notice in the newspaper?
So again,
My understanding is that the procedure is that it does get published in the newspaper.
Is that Mr. Mukai?
Yes, I'm sorry.
John, you'll have to get either closer to the microphone or reach deep inside. Speak louder.
Yes, it is published in the newspaper.
It was published in the newspaper. Is there a copy of that?
Part of the record on appeal.
It's in the record on appeal?
I don't know.
Yeah. I'm looking through it and I can't find it. It's not in there?
Chair?
Okay. Yes.
I have a question. Is that fulfilling rather than letters and letters, notice of service to the individual property owners? Is that sufficient just to post it in the newspaper rather than sending out letters? Because I think it requires individual letters going to property owners, and I don't know if you can do one or the other, or you can do both. But I always remember the process is sending out certified letters to the property owners within that 300 feet. And another question I had is, are any of the people within 300 feet are part of the subdivision? Do their lots fall within the subdivision or not?
So the first part of your was an observation on your part, or was it a question about a requirement of a certified letter to be noticed? That's your first question.
The first question, does a notice to the newspaper circumvent or preclude or eliminate the need to send out personal certified letters to property owners within 300 feet? That's my question. If you post it in the newspaper, are you released from the requirement of individually sending out notices to the property owner? That's my question, because I always thought, especially when I went through the process, I had to send out certified letters to property owners.
So under subdivisions 2317, procedures for variances, it states that such proof may consist of certified mail, receipts, affidavits, or the like, referring to notice to the surrounding property owners within 300 feet. So that's the requirement.
So the word like is what we're saying?
I'm sorry, could we have uniform muting except for the speaker? Thank you. Okay, go on.
Yeah, I just wanted to clarify if that's you know, you can just post it in the newspaper and not send letters. If that qualifies for the and the like newspapers, or because I always thought it was direct mailing to the property owners. I just
so Steve, specific to variances 2317, it states that notice shall be served on owners of interests within 300 feet. So it's specific to those owners. And so then again, the proof is, again, certified mail, receipts, affidavits, or the like. So you could swear you did it, or you could establish through copies of receipts or the certified mail that you have done that.
So in this case, certified letters were sent out to the property owners, except for Kona, the subdivision owners. Do we know that certified letters were sent to the individual owners?
Ms. Logan, do you have an answer to that?
I do actually. Those letters were not sent because we never received the letter acknowledging from the county that the package for variance was actually found to be complete. And I believe they sent the letter for variance approval to the surveyor. If you look on the back of the letter, so the requires a acknowledgement from the county. That they did send a letter, but we got it so we could start counting. I can't tell when the surveyor received it. But again, they were notified in the newspaper and by the sign. I'm not sure, maybe somebody can clarify in the code there whether those three items say that it's and or. I'm not sure if it reads that way. I don't have it in front of me.
For the planning department, you can look at the
Mr. Matsukawa?
Yes. On that narrow issue that Ms. Logan raised on the record on appeal at page 23, the planning director wrote a letter to Paula Alu Trust on February 11, instructing her to comply with section 23-17.
That's noted. Do all the members of the board have that in front of them on the record on appeal, page 23?
Thank you. Yes.
Okay. Let's see, where are we in our process? Who? Stacy, please continue. Okay. Stacy?
My question regarding the validity of the notification by sign, which when I read the 23-17, the sign notification appears to be appropriate and sufficient without, does not state plus have to mail a certified letter. My question is, did the sign, because I can't see the picture, it's part of the record on appeal. It does have a proof of notice by Christie A. Logan with a picture of the sign that was posted accordingly adjacent to the property is what the sign specifications require. But the question is, because we can't read the verbiage, does the sign state that the property owner is requesting a variance from the county and with their subject intentions? Because if it does, my question is, because if it does, it seems like the sign fulfills the requirement for notification to the surrounding properties.
When the sign was posted.
Chair, this is John Mukai for the planning department. I think if you look on the record on appeal at page 20, whatever this is, this last one, the Holy Spirit Association for the Unification or whatever it is, that's what was on the real property tax map. And so this may be Mr. Matsukawa's client, I just don't know.
I'm sorry, could we get an answer to Stacy's question regarding whether the sign met the basic requirements? And then I have an additional question. Did we lose the chair?
Yeah, Stacy, is your question whether the sign replaced individual notices?
I have a two-part. No, actually, I have my question was, because the picture in the record of appeal of the sign is not clear and visible, did the sign language state that the property owners were notifying the surrounding properties that they were going in for variance and identifying the nature of why they were posting a notification by sign? And my statement was, so that was number one question. What did the sign say? Because we can't see the language. But my statement in regards to section 2317 on the procedure for variance notification, in my interpretation of reading it, the posting of a sign qualifies as notification to your surrounding properties. And it does not say, in addition, you must send out notified letters. I guess my question is, one, what is the language that was noted on the sign? And did it actually clearly state that they were going in for a variance request? And two, one of the criteria for where the sign is posted, sorry, I'm trying to find that section. It clearly states where the sign shall be posted adjacent to the property requesting the variance. Anyway, so my first question is, what is the language in the sign state?
It's like, oh, you have to do all these.
Yes. Ms. Logan, do you have a record of what that sign stated in front of you? Because again, I agree with Stacy, that's illegible. That photograph doesn't provide us any information or enough information to determine what the sign says.
I do not have it currently in front of me, but I have the photo that was taken of it. But I'd have to dig it out. So if you give me a moment, talk amongst yourselves and I'll see if I can dig it up. I would say, does Mr. Mukai have the planning department's file that actually would show printed that maybe he could read it? I'm not sure.
Chair?
Yes.
I want to make a point here. I've been through this process before as a landholder and serving notice. A lot of properties are not owned, are not habitated by people here. They might be on Oahu, they might be on the mainland, they might be in Germany. So your duty is to notify all property owners within 300 feet, whether they live here or not. Putting a sign it doesn't help anybody living in Oregon or California. And I've been to this property, so somebody living in California might have objection to my subdividing my property. Therefore, a sign isn't proper notice to a landholder. I've been through the process, and you cannot just post a sign because you have absentee landowners and they may have an interest against a variance or a subdivision or something like that. So I think this question is mute. I don't think that is proper notice because I've been through the process a few times serving notices to property owners within 300 feet. And I didn't merely place a sign because of absentee landowners.
Yeah, so Steve, thank you. And to Stacy, council has advised that in reading this statute, we take A, which is the notice to owners of property interests. Those are the ones within 300 feet. And we have requirements regarding direct notice. Then under B, there's a notice by publication. C, there's a notice by posting signs. Each of those is required. One does not preclude the other according to council. Is that correct? Yeah. So Steve, your experience is accurate. That does require specific notice. And to Stacy, the posting of the sign does not preclude the requirement for direct notice.
Oh, Chair.
Thank you.
Thank you. Yes, Mr. Mukai?
I don't know if you heard the last time, but on the real property tax map, the notice was sent to this Holy Spirit Association and noted on page 20. So I'm just wondering if that in fact is Mr. Matsukawa's client.
Mr. Matsukawa, did you hear Mr. Mukai's question?
Yes. That is a separate owner, not the association, and the tax map key is not the roadway.
Okay, so the tax map key that's affiliated or stated next to this entity, the Holy Spirit, is not the roadway lot.
No, that's homestead lot number 71.
All right, thank you. All right, let's see, are there any further questions from any board members?
Chair, this is Kimball.
Neil?
Thank you, Mr. Chair.
Heather? Yeah, Neil first.
Okay, thank you. Somewhere in the record, there is a statement from the county that they sent out the notice and it went to the wrong address. And the county's point there was that that a party that has an address on file has a responsibility to keep it up to date. Could the party speak to that claim?
Thank you. Mr. Mukai? Mr. Mukai?
I have Mr. Yi address this very briefly.
We cannot hear you.
Oh, sorry.
So when people put together a list of who they have to contact, they pull a list up from real property tax records. And so it's whatever they have filed on real property tax records. I can't tell without doing more investigation right now if that list was inaccurate or whatever. I don't know, but we're only required to use the address that real property tax has on file.
Okay, so are you saying that the association did not have an address on file, and that's why they were not noticed?
Yeah, I can't tell you at this moment in time.
Okay. Let's see, who is next? Heather?
Yeah, I was looking for the TMK for the roadway, but I found that since and the deed. But I just want to clarify, is the assertion that none of the property owners that should have been notified were notified, or just the association? It sounds like none were directly notified, but I'm not clear on that.
Ms. Logan?
Yes, it's correct that none were notified, and the reason for that was that if you read in the code, we're required to send that notification within 3 days after having received the planning department's letter stating that they accept the application. And that letter never in fact was sent to the Alu Trust or the Fugas. So it was never received, so the notices didn't go out.
And is the letter that you're referring to that was never received, is that the letter dated March 23rd?
It would be the letter that states this is again an acknowledgement that we've received your variance application, and then stating everything that you're supposed to do, like notify your landowners nearby, posting of the sign. And so wasn't ever received. This was posted fair after that didn't require a receipt of anything. When it comes to the notification of the landowners, we can't send out notices if we don't know whether or not the variance application was complete and accepted by the department. So that's the reason for that.
Sure.
And then the reason.
Yes, I'm sorry. Please continue, Ms. Logan. Ms. Logan, please continue.
She's talking, but not.
Can you hear me now?
I think we've lost.
No,
now we
can you hear me now? Okay. So the reason why the
Yes.
road association was not on that list was because I didn't interpret the roadway lot to be a property of like homeowners are, and wanted clarification from the planning department. That letter never arrived, and it was right around the time when COVID was, people weren't working in their offices, you couldn't get a hold of anyone, and so we just were, every day it was like, what's in the post office box? Do we have the letter yet? etc. But we couldn't get clarification.
Chair?
Yes.
Yeah, she says that the letters didn't go out because they didn't receive acceptance of the variance. However, the letter on page 23 dated February 11 states the requirement no later than March 23rd. So not precluding when the application was approved, this variance application here required them pursuant to section 23-17 to send out those notices. So I don't see why they would have to wait for an acceptance, because this letter clearly says that within no later than March 23rd, they would have to send that off.
Sorry, but which letter are you referring to?
Ms. Logan, he's referring to the letter February 11th, 2020 to the Paula Alu Trust, and it's page 23 on the record on appeal. The index to the record on appeal.
Just give me a second here.
This was P.O. Box 4614, Kailua Kona, Hawaii, and Are you saying that this letter was never received by the Paula Alu Trust?
I'm not sure now because there's multiple letters that we're talking about. You said what page in Mr. Matsukawa's?
Page 23. No, index to the record on appeal from Mr. Yi, the planning director.
Oh, it's
published
from
the
the
record
planning
on appeal.
directors?
Yes.
I'm sorry. If there's a letter that gave a date that sent, and it's not the letter, it's a different letter from the acceptance of the variance, I'm just confused and I can't answer the question other than, like I said, the letter didn't go out to those people. We were waiting, I was waiting for a letter of acceptance from the county because I can't, before that letter arrives, what happens if the Department of Planning rejects the application? It has to be redone. Then, so that's why the letters didn't go out. I'm not sure which letter Steve's referring to. I don't have it in front of me.
So you don't have the index to the record on appeal in front of you?
I have a lot of things here in front of me, and is it an exhibit?
Well, yes, take a moment to find the index to the record on appeal. Any other questions while you look for that?
I don't have any
anybody
other
else have?
questions.
Okay.
Page 23 is it.
So just for all the board members, it is in the index to the record on appeal on page 23. And further to that, in the motion to dismiss, there's a follow-up letter on March 23rd. That is the approval of the variance. This of February 11th is the notice that your application has been received, it's complete, and they will render a decision no later than March 23rd. And that's the time when you would have been required to notice the surrounding property owners. The approval did go out.
And it's stated that they have to.
Yeah, and it's clearly stated in the February 11th letter that within 3 working days of receiving this letter, that those notices are to go out, as Steve Hirakami and others have pointed out. Heather. All right. Let's see.
I'm sorry, Mr. Chair.
Sure.
That letter, that February 11th letter,
yes,
that says your application is incomplete and you have 3 days for it to go out, was never received by us. The PO box number that you gave is the Alu Trust never received that.
Okay. Is the PO box 4614 the Alu Trust PO box?
1 second. No, that is not the PO box for Alu Trust.
Okay.
PO box 196 is the Alu Trust PO box. Kalikakua.
The application.
Yeah, the PO box 196 Kealakekua.
That's the address that would be correct. Which I believe was on the application.
Yes. Okay.
That's page 27.
Uh-huh.
So there's the one just to take a minute.
Okay, well, whoever resides at PO Box 4614 probably has something in hand that they don't understand. And that seems like it was a clerical error, which happens from time to time.
Chair.
Yes.
Clerical error would be like a different box number, but the mailing address between Kealakekua and Kailua Kona with different zip codes is not a clerical error. This is we have to get to the bottom of why this letter was sent to that, because it might have been mentioned in another communication, but you just don't make up different PO boxes and different cities, and that's not a clerical error. So we need to research where planning got the PO Box 4614. I don't think they made them up. I don't think it's a clerical error. I think it's somebody's mailbox. Because if you look at the zip code, it's 96745-4614. So that's somebody's actual PO Box.
Okay, thank you, Steve. Yes, Christy, Logan, and then Mr. Matsukawa.
Yeah, so I believe that PO box belongs to Mr. and Mrs. Fuga. I'm pretty sure, and they were not the address that was, they were not the one directly. Paula Alu Trust was the one that filed the variance. So I'm not sure why they send it to Fuga and not to Alu. And so that address does live in the record probably someplace between the subdivision paperwork, and I'm not sure. I also don't know why the letter was sent to us, to the surveyor, and not sent to either the Fugas or the Alus.
Chair, if you look on page 1, the owners are Paula Alu Trust and Shauna Fuga and Laupama Fuga. So they're listed as an applicant. So there are co-applicants. It was sent to one of the applicants. So I'm sure if they filed this application for variance, they must be in communication with each other. So that address wasn't a mistake, and they're co-applicants in this case.
Chair.
Yes, thank you. Yes.
Chair, it's Stacy, and also the certificate of service, the last page of the index to record on appeal also lists that PO box as the Paula Alu Trust and the Fuga record of address.
The last page is the record of
Yeah, duly noted. Thank you. Yes, Mr. Matsukawa.
I just wanted to add that in the subdivision, the separate subdivision record and appeal at page 3, the applicants for the subdivision in question are the same parties noted as the applicants for the variance, and it carries the PO Box 4614, Kailua Kona.
Yes. Okay. Let's see. Yes, Neil. No. Yeah. Sorry.
Mr. Chair,
yeah.
I'm just starting to formulate a question of where we go from here. Could you perhaps identify what our choices are? Because it's tempting to think that this has been scrambled enough that maybe we should, deny this motion to dismiss without prejudice and make them go back and do it over again. Is that an option?
Let me confer. Thank you. Yeah, so the board the board has that option. Why don't we?
Does he want to make that resignation? Sure.
Yeah. So at this time, the chair will entertain a motion if you so choose to make a motion. Yes, please. I'm sorry. Up in the upper right.
Ms. Logan.
Ms. Logan.
So I just happened that my thought, because I still have a motion to dismiss on grounds that a variance is not appealable. It's not a final decision. So if you vote to make us do it all over again, where does that leave my motion that we haven't discussed yet?
I think it leaves it in the queue.
Okay,
in other words,
and
we're
so-
dealing with motions one at a time. So
Right.
this motion to dismiss is what I'm going to entertain a motion in regards to as how the board will respond to that motion.
Okay,
Because of timeliness,
then-
because of timeliness.
okay, all right. I'll just wait then until it's my turn for my motion. Thank you.
So at this time, do any of the board members, are there any further questions or anything that you want to raise, Mr. Matsukawa?
Only as to the location of the sign, but from what I understand, that's not really the gist of the board's concern, so I won't have anything more to say.
Yeah, that would seem secondary at this point. Mr. Mukai?
No, nothing further. Thank you.
Okay. All right, so the board has a motion to dismiss from the appellee and just from the planning director. The chair will entertain a motion at this time.
Chair?
Yes, Steve?
What if nobody makes a motion, then it dies? If somebody from our board doesn't make a motion, does it die?
Well, in this case, I mean, this is a dispositive motion, so I suppose, you know, if they need to do something on it.
Well, yeah, so.
We take some kind of action
Yeah.
on it.
Council makes the point that this is a dispositive motion, and so it has it's a binary. It's either up or down. We have to make a decision, Steve. So at this time, the chair will entertain a motion on the motion to dismiss based on timeliness.
So do we have to do it in a positive way? Like I move to dismiss. So
You could move to approve or deny the motion to dismiss based on timeliness.
yeah, I make a motion to deny the request.
The motion to dismiss based on timeliness as submitted by the planning director.
I would second that motion, Chair.
Thank you, Justin.
Okay, so then we need to.
Okay, any discussion by the board members on this matter?
Mr. Chair?
Yes, who's that?
Neil Thomas.
Neil. Okay.
The motion is before us, and I'm not sure what it means if we grant this motion. If we grant the motion and we dismiss because of timeliness, then where is the case? Are we proceeding to the merits? Or do we have to vote the motion down? I guess I'm not sure what the effect is of voting one way or the other.
My motion was to dismiss that, to deny the motion to dismiss. So I'm denying that, and then we can move on to the merits of the case. That's what I'm thinking.
Or we'll move on to Ms. Logan's motion.
Yeah.
So in answer, Neil, if we approve Steve's motion, we will then continue on with this matter. If we vote against Steve's motion to deny, then I would need an affirmative motion.
Okay, is the motion, you need a motion to deny it.
Yes.
So if you vote in favor of it, then we're going to hear the case. Yeah.
Yes, and if we don't vote in favor of it,
then you are, you would need an affirmative motion.
yes. So first, let's deal with Steve's motion to deny the motion to dismiss. So I have a motion and I have a second. And I've had a question. Are there any other questions? Or discussion for that matter? Anything to observe? If not, yeah, yes?
Mr. Chair, I'm Neil Thomas again. I'm sorry to be new and therefore not being clear. It seems to me that we have a motion from the county in front of us, and that it's not the function of the board then to create a motion, or am I confused about this? Don't we just have to vote the county's motion up or down?
Agreed. That's a fair point. Thank you for joining our board.
Now, then my question becomes, if we vote yes on the county's motion, then we are dismissing the appellant's appeal because of timeliness, right?
Correct.
And where does that leave us?
Well, it leaves us to move on to the next matter, and it moves which is a second matter with this same appellant. It would end this appeal, this motion. It would end it if we dismiss for lack of timeliness.
Chair, can we move to take a vote?
Yes. That's what we're moving towards, Stacy. We had started with a motion from Steve to deny that I had requested, which was a mistake. And I think Neil made the point fairly that we should just have a vote on the motion to dismiss as submitted by the planning director. And this is narrowly based on timeliness, this motion to dismiss.
So the motion is amended? Okay.
No, it wouldn't be amended. It's just his motion to dismiss.
Okay.
So on the matter of the motion to dismiss as that's before the board from the planning director, we're going to take a vote.
Do a roll call.
We'll do a roll call. So.
Want me to read that?
Yes, thank you. Bethany?
So we don't have a motion and a second. I'm just confirming what is happening here.
Yes, we're voting on the motion to dismiss.
So we'll just do the whole, okay. So Stacy Aguiar?
No, Chair, are we voting on my motion or the county's motion? Are we voting on motion to dismiss, or are we voting on my motion to deny the motion to dismiss? There's a big difference between how I'm going to vote. What are we voting on? Make it clear.
Yeah, thank you, Steve. So again, as I said just a moment ago, I believe I incorrectly requested a motion on the motion. So we have a motion to dismiss in front of us by the planning director. We're going to vote in favor or against the motion to dismiss.
Thank you for that clarification, because I would have voted wrongly.
Okay.
Yeah, this is Heather Kimball. If I just want to make sure we're all clear, a yes vote on this at this time would mean that we dismiss the case. A no vote at this time would mean that we do not dismiss the case and proceed to hearing.
That's correct.
We'll hear from motions.
We'll hear other motions. I'm sorry. There's more to go here. But yes, the case will proceed. So yes stops this case and no continues this case. Is everybody clear?
Clear.
Clear.
All right. So now we're going to take a roll call vote.
Okay, on the motion to dismiss, Stacy Aguiar?
No.
Steve Hirakami?
No.
Springer K?
No.
Heather Kimball?
No.
Justin Lee?
No.
Neil Thomas,
No.
Chair McCauley,
Chair, no.
unanimous.
All right, thank you, board. At this time, we're going to take a break, a brief pause for a good cause. So I will see you in 10 minutes.
10 minutes?
Wow. open hearing. I think we have stragglers.
Once you leave, it's hard to come back.
As compelling as this is. Yeah, so we're going to need to have this ready for us, given that she's going to perhaps.
Okay, so what section is this come out of? 25 to, okay.
Is it a bad thing that those people were sent to the wrong, that acknowledgements and that people were sent to the wrong address?
But it wasn't. It was the address of the co-appellant.
Additional addresses.
There were additional addresses there. So it wasn't totally wrong. They were one of the parties to the appeal. It said co.
Hello, Board of Appeals, September 11th, back in session. Again, I'll take a quick roll call to make sure we still have quorum. I see Steve Hirakami.
Present.
Stacy, you're back?
Present. Present.
Great. And Springer?
Present.
Thanks. And Heather's here?
Present.
And there, Justin?
Present.
And Neil?
Present.
All right. We have our board back in session. When I read into the record the agenda item for AOPOO KOVP Incorporated, BOA 2000270, we had two appellees, the County of Hawaii and the Alu Trust, as represented by Ms. Logan. Ms. Logan has advised the board that she wishes to file a motion during the hearing, but she did provide us with some evidence apparently, or some supporting documents prior to the hearing, so it's something that she had intended to do, I think. But you can do this under our Rules 312. So, Ms. Logan, at this time, do you care to make your motion?
Yes, Chair, thank you. So I'd like to move to amend.
Christy, Christy.
Is not an appeal under the county charter and the rules.
Christy, your audio is in and out. You're breaking up. Yeah, can you speak a little closer to the mic? Okay, start over again.
Or,
Keep going.
Sure. Is that better? I would like
No, it's not. I'm sorry, it's not.
this for untimeliness when this decision is appealable to the board. Can't hear me?
I'm sorry, Christy. Ms. Logan?
I think she's trying to reconnect.
Oh. Board staff believes she's reconnecting. Ms. Logan?
Can you hear me?
Yes.
Okay, I came in on a different device. Let me go get my
Okay,
paper.
keep going. Sounds good now.
Okay, I'd like to make a motion to amend my motion to dismiss for untimeliness to a motion to dismiss based on the fact that this variance is not an appealable decision.
Okay, what is your basis for that?
My basis for that is the fact that I'm sorry, are you approving my motion to amend?
No?
My basis for
You're presenting your motion. We don't have a written record in front of us, so I want to understand what your motion is.
Oh, okay, I see. Chapter 9, Section 6, 9.2 of the county charter states that the BOA shall establish its rules of procedure and shall, A, hear and determine appeals from, quote, final decisions of the planning director. This variance lives within the tentative approval. If the subdivision doesn't happen, the variance goes away. So it's not final in that nature. This variance is not an appealable decision by the director because it's not final. In Kelberg versus Ewan, which is exhibit 2.1 that you folks have, you'll see where the Supreme Court states the differences between any decision and final decisions. Not every decision that the director makes is appealable. Only final decisions are appealable. So my motion to dismiss is on those grounds. Somebody go get me the other paper, other chair. It's got pink highlighter on it.
So, Ms. Logan?
Yes, sir.
Under the county code 25-258 appeals.
Yes.
Are you familiar with that?
Not off the top of my head.
Part B says, any person aggrieved by the decision of a director in the issuance of a variance decision may appeal the director's action to the Board of Appeals in accordance with this chapter within 30 days after the date of the director's written decision. Now there we have a defined moment in time.
Sir, if you would read...
The date of the director's written decision.
Well, there is not a definition of, quote, the decision. You have to go to the county charter to see that the board is empowered to hear only final decisions. And the board cannot exceed the powers that the charter gives to it. As it says as the Supreme Court says in Exhibit 2.1, neither the county code nor the BOA rules defines the phrase, quote, the decision. However, the county charter, which establishes the BOA and its jurisdiction, specifies that the BOA, quote, shall hear and determine appeals from final decisions of the planning director. And then, accordingly, when reading the county code and BOA rules in concert with the county charter, it is clear that only the planning director's final decision is appealable to the BOA. That's in Ewan versus Kelberg, Supreme Court, case that was cited by Mr. Matsukawa.
Do you have anything further to add to your motion?
No, these are the grounds for the motion, that this variance is not final.
Okay.
It is not a final decision.
Mr. Matsukawa?
Although the motion to amend, I think, is untimely, the board always has the inherent right to determine its own jurisdiction. So I would just direct the board to the chair's description of the code that says a variance decision is appealable. Even though the variance might be related to some other permit, the variance is a separate, independent form of action. The decision thereon is therefore final because there is no further action given to anyone to do anything further once the decision to grant a variance is made. So therefore, what the board has before it, the variance, is in fact a final decision that the board may entertain review on. Thank you.
May I speak?
Ms. Logan, rebuttal?
The rebuttal is that Mr. Matsukawa himself has said that the tentative approval, which obviously isn't final, makes the variant, puts the variance within it. If one falls, the other must. So now he wants to say that it's a final decision, but in fact it isn't. If the tentative approval goes away or the subdivision doesn't happen, there's still more things to go. The variance is not final. It won't exist if they prevail. So it's not final. As well as the tentative approval is not final either. It's tentative and can be amended. Because one more thing, if and when we go through all of this and we have to go back and do this all over again, and the director issues a new decision of a final subdivision approval, then there would be saying that they could appeal that as well and have another bite at the apple. The case, the Supreme Court says that given that a final decision settles a matter, it is implicit that there can only be a single, quote, final decision that may be appealed per the County Code 23-5 and BOA Rules 8-2. And that they refer to the decision in the singular. So says the Supreme Court.
Thank you, Ms. Logan. Mr. Mukai, do you have any position given the director?
No, but I believe the chair properly cited the rule. Nothing further.
Ms. Logan, the chair has in front of them a March 23rd, 2020 letter where the planning director certifies the approval of the variance. Do you consider that a final decision at that time, March 23rd, whether the underlying matter of February 11th was correct or not? Is that the actual final decision by the planning director on this matter?
No.
And the reason it's not?
I do not consider it a final decision in the context of the county charter or the BOA rules as to what a final decision is. This all still has to go forward for something else, and then the roadway association can just get another chance to appeal.
So in this matter, the roadway association under 25-258, you don't consider them to be aggrieved by this decision?
No, nothing. This is not finalized. Their grievance has always been with the subdivision. This lives within the tentative approval and the subdivision process, which is exactly what Mr. Matsukawa said in one of his exhibits. And now he wants to separate them and say that the variance is a standalone. It's not standalone.
Okay. Let's see, Mr. Matsukawa, any further comment?
None, Your Honor.
Hardly.
Chair.
I'm sorry, members of the board?
Chair, yes?
Yes. Yes, Neil?
Based on this latest amended motion, I would like to Move to go into executive session to confer with our attorney on matters of our duties, privileges, liabilities, and manners of law.
Thank you, Steve. Do we have a second?
I second.
Was
Stacy.
that Stacy?
Yes.
Thanks.
We need a roll call vote.
And we'll do a roll call vote now?
Okay.
Bethany's springing into action as soon as she gets our roster. Do you have it?
Yes,
Okay.
and this is on going into executive session.
Yeah, and before we take this vote, on a matter of timing, I think we are tolling at 12 o'clock today. Is that correct for this?
That was what was.
That was what was published, is that we were going to go until 12 o'clock. So at this time, we may run out of time. So I just want to advise everybody that we are under a time constraint. All right, so with that, we will go into this vote.
Stacy Aguiar,
Yes.
Steve Hirakami,
Yes.
Springer K,
No.
Heather Kimball, Heather, I think you have to verbalize your vote for executive session, yes or no?
Did it go now? Yes.
Justin Lee,
Yes.
Neil Thomas,
Yes.
and Chair McCauley.
Yes.
Okay, you have one no vote.
So at this time, we have to go through a technical process.
Yes.
It will now be explained to us by somebody smarter than me.
Yeah, so let's that paper. Okay. Members of the board, we will be leaving this particular session. We will be sending an invite to you separately for a second session that will not be open to the public and will not be on YouTube screen. We will go into that second room then and complete your executive session. When that is completed, we'll leave that room and enter back into this WebEx session. So your next move will be to get an invite from Rob Leisure to a second WebEx session.
So that will be by email.
Yes.
Oh, okay.
So check your emails.
We're not in executive session.
Let your fingers do the walking.
So go ahead and mute us.
So we'll X out of this session at this point.
Usually we keep it going, I thought, and then when we're done.
So just to confirm, I'm sorry, this is Keiko. We are going to keep this session open here. If you are a board member, then you would exit this meeting and enter into the meeting that Rob is currently sending you a link for. And this meeting will stay up. I'm going to share my screen that says something to the effect that we're in executive session so that folks who are also watching on the YouTube channel will be able to understand where we're at.
Thanks, Keiko.
Sure.
We're gonna go in executive session.
Mahalo for your patience, everybody. We're slowly making our way back into this main meeting room. So just stand by a little while longer. Mahalo.
Hi. The Board of Appeals, September 11th, is back in session. I'm going to take a quick quorum count. Stacy, are you available?
I'm here, present.
Thank you. Steve, how you doing?
Present.
Good? All right. Springer? Great. Heather?
Present.
You're good? Thank you. Justin?
Present.
Thanks. And Neil?
Present.
Thanks. All right, so our counsel, Ms. Lacey, Mellon Lacey, has advised that we have a conflict in the sense that we have a calendar that scheduled us to end on the noon hour, which we're already past. And we have other agendas that have been printed and published that don't provide that ending point. In an abundance of caution, I'm going to take council's counsel and make sure that we don't have any conflicts with the public's interest, which is their ability to participate in this hearing. So I'm going to bring this hearing to a close, and we're going to continue this matter on the next date, which is October 9th, at which point we will continue the matter that's currently in front of the board, which is the motion by Ms. Logan regarding the planning director's decision. So at this time, I'm going to close the agenda.
Can I just confirm that the next agenda item will also be continued to that date?
Yes, that would be the BOA 2000271. Because we were doing 270, were we not? Yes. All right, so at this time, yes.
Chair, I'm sorry,
yes.
I have a question.
Yes, Justin.
Does that mean Ms. Logan is allowed to make filings before the October 9th date or not?
She can make motions and do filings at any time.
Thank you.
Matsukawa has a question.
Mr. Matsukawa.
Mr. Chair, might I suggest that we allow the landowner to file her motion in writing and give the parties an opportunity to respond and fix a deadline for such filings to be done?
I don't know that the rules require that she put it in writing, since she raised it here and we're continuing it. But that, you know, that would be appreciated, I think.
So, Mr. Matsukawa, council agrees that your intention is well-founded, that it would be in the board's benefit to have something other than oral, and that would be incumbent upon Ms. Logan to decide whether she chooses to do that or not, or leave us with what she's provided on an oral basis. It would behoove her more likely to be able to support her motion in a way that we can review prior to that hearing. But I don't think I can order her to do that. Yes?
Yeah,
Ms. Logan?
you don't have to order me. I'm very willing to supply written, like what Mr. Matsukawa is suggesting. We just need to know the deadlines.
I would think 2 weeks prior to the hearing. The hearing is on October 9th, so if we check our calendars, we'll establish a date of September 25th. And responses would be by October 2nd. Mr. Matsukawa, are you in agreement?
Yes, I am, Mr. Chairman.
All right, thank you. At this time, given that we're past due on our public hearing, I'm going to close that portion of our Board of Appeals, and I'm going to go on to administrative matters. And so participants in the hearing can choose to leave. The board members will just go over the fact and get approval of minutes and do things of that nature. So at this time, I'd like to thank the appellate and the appellees, and we're going to move on. Okay. So we have minutes from August 14th. That was our first virtual hearing. I don't know, has anybody reviewed them? Can we get a motion to accept?
Sharon, so Heather Kimball will make a motion to accept the minutes.
And a second?
Yeah.
Second.
Moved by Springer and seconded by?
Neil?
By Neil. All those in favor say aye.
Oh, we need to do it.
I'm sorry, discussion?
Hearing none, you can call for
Hearing none, I will call for the question.
Stacy Aguirre? Oh, I'm sorry. I gotta go with Springer.
Aye.
Neil?
Yes, aye.
Stacy Aguirre?
Aye.
Steve Hirakami?
Aye.
Heather Kimball?
Aye.
Justin Lee?
Aye.
And Chair McCauley?
Aye.
Unanimous.
Thank you. In administrative matters, I'd like to get a report from our Corp Counsel or staff regarding the status of appeals and status of outstanding petitions.
Okay, I have no update on the appeals. There's no change from what I reported last time.
Thank you. Diana? And Bethany?
I guess I can just let you know that we will have then 4 cases to hear on the October 9th next meeting. There was still a question about having a special meeting. That is open to Chair and the board if you guys wanted to have a special meeting.
To fit something in.
We'd have to make notices.
We'd have to,
Yeah. So are you referring back to earlier interest in rulemaking? Yeah. So, board, in the past, members have discussed whether we need to clarify some of our rules, and to do that, we would have to schedule special meetings to discuss that, so we would have the time. So, I'd like you to give that consideration and think about that, and then when we have our next meeting in October, if you have specific interests and goals in the rulemaking, then we will move towards scheduling a hearing, a special meeting on that subject.
Thank you, Chair. I just wanted to let you know I won't be available for the October 9th meeting, but I am interested in pursuing the rulemaking. So just wanted to share that.
Are you traveling?
Sadly, no. There's no travel.
Okay, just checking.
Just some things that can't be rescheduled.
Understood. All right, thank you for letting us know. All right, any announcements other than Springer's? Hearing none, I adjourn. Oh, Stacy, sorry.
Actually, I have a question. Since we're going to continue to do this remotely, is it possible, or do you folks feel it's helpful if we could get a list of or an index of the documents we're supposed to have had received for each case? Because I don't know what we're missing. If we're missing something, we don't know we're missing it.
Yeah, so we know that for each matter, we have the index to the record on appeal, but we also know that there's numerous filings after that by some parties, and that is not indexed. And so fairly noted, Stacy, and maybe that's something we bring up in our special meeting about a concern of ours. It's not necessarily a rulemaking.
I can do an index on this one that we have so far on that prior to the next meeting.
So Melissa is offering to do an index of everything she has for this case prior to the next hearing.
Yeah.
I mean, the trouble with that is sometimes people file things later
Last
on.
minute, yeah.
But she can do it for this case.
The association one or all of them? Association one only?
I think she's, are you looking, she's asking if possible, you want this for all the cases?
Or just the association?
That would be helpful, and at least with enough time that if we are missing something, we figure out how to print it on our own or request it.
I'm sort of looking at Melissa, but she's the secretary.
We'll have to think about that, Stacy, trying to monitor like who gets electronic versus paper, and then an index is an additional ask. And so we can definitely do it for these particular ones that you guys, that there's a lot of kind of paper shuffling already for the AOAO one. And then we can look at how we might be able to do that for future ones. Does that work?
Yeah, and maybe if the rule of thumb is the standard appeal package is the appeal or the filing, the chair's letter of receipt or acknowledgement, and the planning director's record on appeal. If that's the standard 3 documents, that we just get notified if a case has anything in addition to that.
Okay, that seems fair enough.
Awesome.
This is Steve. Rather than us all hunting through our volumes of paper or on electronic screens, is there a way perhaps for a clerk or somebody to screen share, and if somebody mentions a document, then they bring it up on the screen so we can all see it, and not hunt?
I thought of that too.
That's another thing that we are trying, and there was a little bit of conversation in the chat about that. It has to do with permissions, and so it might be something that only the host can do, but we don't want to share that to other parties. So we have to still work on the procedures for that, Steve, but we hear you, especially if people are presenting evidence. That's something that came up is can they provide evidence in the hearing via a screen sharing. So so we are working on that option.
Because
we just need to figure out what the protocols might be for that.
Yeah, but this is the paper, and then I had my backup computer just in case I was missing paper, but still it's hard. Like in the Mauna Kea properties, we had like stacks. And it was really hard when somebody did a referral. We'd individually have to go, oh, where's that? And so I was thinking if somebody could be and just share it for us all. But we can work it out. It's just, I find a way to find it somehow. Yeah.
Understood, and we are working towards that. It just is making sure that we can handle that staff-wise.
I had a quick related question. What is the proper process for disposal of
Who's that?
Oh, this is Heather. Yeah.
Hi.
So for cases that have been, either removed or we've made our decision on, what is the proper process for disposal of those printed documents? Do we have to return those to you, or can we just, what do we have to do with those?
Yeah.
The ones that they have.
Recycle, Heather, recycle.
Well, I didn't know it was fine to put it, is it fine to put it like in the public recycling? Or, is there confidentiality concerns, privacy concerns?
They're public records. I suggest mulching your vegetable garden.
I had no idea you were so green, Jim.
Well, you know, with Mauna Kea, I could do the whole farm. All right, anything else from anybody else? Otherwise, I'll adjourn the meeting. We're good? All right, thanks. We'll see you.
Is that your gavel?
That's my gavel.
Well,